Well,
we kind of can't, because what should be in the public record, or at least viewed by the State Department, has been scrubbed.
So I guess that's the next question, David. We have these things stacking up. Is it fair to actually ask, again, going back to the email controversy, whether in fact there may be information there that could help us figure out whether there was a quid pro quo? Because at the end of the day, that's really the question here that has to be uncovered once we investigate it. Does a lack of email, a trail of emails, does it make it harder to do that? To get to that answer?
Well, 55,000 pages of email have been turned over to the State Department, and those are going to become public. And so if there's anything relevant in there, sure, then we'll find that out. And Secretary Clinton has asked that they become public quickly.
Don't deflect. I'm talking about the ones that were scrubbed. How can you get answers from the ones that were scrubbed that might be considered, quote, personal business? There's no answer, is there?
But there is. Everything relevant to her public duties is in those 55,000 pages.
No, David.
That's the way the law works, Mika.
No, actually, David, you don't have to give me a lesson on the regulations of the State Department. She scrubbed emails because she felt like it, and that went against regulation, and she says they were
did not go against regulation. It totally followed regulation.
David, that she scrubbed emails that she wanted to scrub. Not
it's everybody's call in government to make those choices, Mika. That's how the law works. And so let's not create a double standard.
Are we going to do this again?
No, we've done this before.
You're going to pretend.
Let's talk about Schweitzer,
guys. Let's talk about the book. We've had the debate about the 2009.
We are talking about the book.
The 2009 regulations before. I'm sure, David, after the book comes out, we'll all read it, and let's meet back here again, same place, and talk about it some more.
Be happy.